at the judicial branch today, we're going to be focusing on the court systems of the United States. And the court system's main job is to interpret the law. So we'll start by focusing on the Supreme Court and then the courts that are lower or not as supreme, like the Circuit Court of Appeals and the district courts. And it's important to remember, on top of interpreting the laws, the judicial branch and Supreme Court is also responsible for checking and balancing the executive branch and the legislative branch. The judicial branch can declare executive actions and orders unconstitutional, and for the legislative branch, they can also declare acts of Congress to be unconstitutional.
You can't touch this.
The most powerful court in the United States is the U.S. Supreme Court. While there's no jury, there are 9 justices. These 9 justices have very limited original jurisdiction. However, most of their cases that they do hear are appeals on previously decided court cases in lower courts. The Supreme Court does still have original jurisdiction in some court cases. Jurisdiction is the authority a court has to interpret and to administer the law. So court cases between 2 states are heard by the U.S. Supreme Court. If a state has a case against the United States, it is heard by the Supreme Court. And if there is a court case involving diplomats of other nations in the U.S., those are also heard first by the U.S. Supreme Court.
Don't worry about me and who I fire. I get what I desire, it's my empire. And yes, I call the shots, I am the umpire. I sprinkle holy water upon the vampire.
Beneath the Supreme Court are the Circuit Courts of Appeals. Again, there's no jury here, and the court only hears appeals or cases that are wanting to have another opinion. A panel of 3 to 5 judges hear out these appealed court cases, and their jurisdiction is to only hear appeals. So even before a Supreme Court could get an appealed court case on their desk, it's going to hit the Circuit Court of Appeals first. From there, it can still move up to the Supreme Court, but those appealed court cases originate in the U.S. Circuit Courts of Appeal. District courts are also important in the United States. It's the only federal court that have jury trials. There is 1 judge and there is 1 jury, and they have original jurisdiction over most cases not specified to the Supreme Court or to the appellate courts. For a different view of the federal court system, you can look at this graph as well, with the U.S. Supreme Court being at the top, and then beneath the Court of Appeals, and then further down the district courts. It also shows you what type of court cases each deals with.
Justice will be swift! Justice will be painful! It will be delicious!
So the great question is, how does the Supreme Court work? So we're going to dive a little deeper into the Supreme Court, how it's set up, and how it functions. As mentioned before, Supreme Court justices are appointed for life by the President of the United States. Supreme Court justices generally fulfill these terms until they pass away or they feel old enough to retire. Supreme Court sessions begin the first Monday in October every year and adjourn or leave in late June. In order to have your court case heard in the Supreme Court level, you need to complete something known as a Writ of Certiorari. This is a document asking the court to hear your case. After hearing a short summary of the case, 4 of 9 justices must agree to review a case in order for the case to be accepted into the Supreme Court review. This is known as Rule of 4. Once the Rule of 4 is in place, that court case will then be put on the court calendar or a docket to be decided upon. Upon reviewing the court case, each side of the argument will present their position in front of the U.S. Supreme Court, and they'll also submit to the court their written arguments. These written arguments are known as briefs. Supreme Court review of cases also allow for oral arguments. In an open and public hearing, each side will have the opportunity to stand before the court and speak their argument out loud, being given 30 minutes to make a verbal argument as well as their written brief. Once the briefs and the oral arguments are heard, the justices go back to their chambers and discuss what their decision is. The decision of the court is then released in written form explaining the reasoning used to decide the case. One outcome of the Supreme Court reviewing a case is a majority opinion. A simple majority of 5 out of 9 decide the case. Once 5 out of 9 have decided, the decision is binding and the case cannot be appealed past this point because the Supreme Court is the highest court in the United States. If you are not in the majority opinion, you are in the dissenting opinion. Any justices with a dissenting opinion must write down why they disagree. Sometimes the dissenting opinion has influenced the future courts to change their mind and to rule differently.
Do you think I want to hear your opinion?
Historically, Supreme Court justices, when they do make decisions, are either practicing judicial restraint or judicial activism. So these two philosophies are how to pass judgment on cases. Most Supreme Court justices who utilize judicial restraint use logic to make their decisions. They rely on previously decided court cases or precedents, and they believe in not making too many new changes, trying to keep everything status quo. A Supreme Court justice who would practice judicial activism uses personal opinions to make decisions, and their decisions usually establish some type of new rule or new law. An example of judicial restraint in U.S. history was the court's decision to not change social rules or laws concerning segregation in the South in the Plessy v. Ferguson case. As a matter of fact, the court established the separate but equal, keeping everything status quo. The Supreme Court had a change in thinking and started showing judicial activism when the court's decision changed social rules and laws concerning that same segregation in the South with their decision in the Brown v. Board of Education, which actually got rid of the separate but equal doctrine, determined it was unconstitutional, and also started the integration and desegregation of schools.